So I'll get started right away because this is a pretty squeezed panel. I think we're going to be a bit pressed for time, so we're going to try to make this as efficient as possible. First, welcome everyone. Thanks to all our speakers and thanks to all of you who are attending this panel and this conference. Before we begin, I'd like to acknowledge that I am in Montreal and some of you probably are as well, and I'm on unceded Indigenous lands of the traditional territory of the Kanien'kehá:ka Mohawk peoples. So my name is Jessica Citron. I'm a member of the conference organizing committee and a lawyer at McCarthy Tétrault, who is the sponsor of this panel. This is McCarthy's second year sponsoring this panel and collaborating with the Canadian Association of Food Law and Policy. And we're thrilled to have the opportunity to bring together such an excellent group of speakers to provide this year's updates on food law and policy in Canada and abroad. So this panel is a mainstay of the conference year after year, and it's an opportunity for a diverse group of experts and specialists across the food law spectrum to share some of the most important updates in their areas of practice or study over the last year. The format will be that each speaker will have 7 minutes to give their update, and once all the updates are done, I'll address one question to all of the speakers, and each of them will have 2 minutes to respond to that question. I don't want to delay longer because 7 minutes is not ideal, and I'm sure they have a lot to say, so I'll stop taking the time up and jump right into it. And I would remind everyone here to, of course, please keep your microphones on mute unless you're presenting. So the first presentation will be on the Canadian Food Policy Advisory Council. We're very lucky to have a member of the council here with us. Catherine Ma is the Canada Research Chair in Promoting Healthy Populations, an associate professor in the School of Health Administration at Dalhousie University, and she is also the director of the Food Policy Lab. So thank you, Catherine, and you can take it away.
Thank you so much.
And I should mention, one thing I forgot to mention is that I think each of you will get a message when you have 1 minute left. So you should get a little chat when you've got 1 minute left to go. All right, thanks, Catherine.
Thanks so much for that. Either that or I'll rely on somebody to wave madly at me. So thank you so much for having me join you today. I would say presenting on the Food Policy Council, the analogy that I would use, and this analogy is particularly for Glenn Jameson when I was thinking about writing it, which is that it's a little bit like sitting down to write about a meal at a brand new restaurant that has been highly reviewed in advance of opening. You've been talked about it many times by all your friends. I've sat down, I haven't quite received the meal yet. I've gotten a menu, and the menu has also just been whisked away by a server to give me a new one. So with that in mind, and that sort of caveats, I'd just love to introduce a couple of ideas about the Food Policy Council, what the mandate and process and kind of where we're at in the Food Policy Council, and then in the spirit of the updates, to actually talk a little bit more about what I expect out of the Food Policy Council and what I hope that you'll all watch for and hold me to account as a member of the Food Policy Council moving forward. So the first thing to say is that I am really honored and delighted to be a member of, to have been appointed as a member of this council. I think, I myself have been thinking and writing about multidisciplinary and intersectoral governance of the food system for at least a decade, and thinking about it for much longer than that. And to have the opportunity now to take a chance at shaping it, quite an active hand in it, is I think just an outstanding opportunity. So the convening of the council itself is an outstanding achievement, I think, for food systems and policy. Now, the question is it also an outstanding achievement in food law and policy? And that leads me to some of the issues that I'm going to raise and things to look out for. But before we get to that, the council itself, just in case, for those of you who aren't familiar, just to bring you up to speed, this council was just announced a couple of months ago. It reports directly to the Minister of Agriculture and Agri-Food, Minister Bibeau, and the mandate of the council is a couple of things. It's to advise on current and emerging food policy issues. It's to enable ongoing dialogue on food, share information and best practices, address data gaps as well as policy gaps in the food system, as well as to advise on implementation of policies and or programs and or interventions in 4 priority action areas of the food system and food policy. And the 4 priority action areas are around, first, healthy food access. Secondly, making Canadian food the top choice at home and abroad. Thirdly, food security in Northern and Indigenous communities in light of reconciliation and moving towards reconciliation, as well as number 4, reducing food waste. The council so far has had 2 meetings, 2 full council meetings. A number of work groups have also been founded, and some of those have met outside of the full council meeting in different ways. And the work groups really are focused around a set of emerging issues, but also very much a function of the expertise of the members who have been named to those various working groups. And we have a third full council meeting coming up at the end of May. The council has also already had an opportunity to speak directly to Minister Bibeau. So that's, I think, an indication of really kind of the profile and the importance of the council to the minister. And that's also a really positive thing so far. So what to watch for? I'll give you, I have about 5, 6, depending on how you divide them up, issues that I'll use in the rest of my time. So the first one that I'll point to is many of you will be familiar, if you're interested in this council development, in the case for a food policy council report that was put out by an intersectoral ad hoc group looking at governance in advance of the council and really kind of pitching some advocacy recommendations on what the council could and should look like. And I see just from the list of participants who are in the audience today, that some of the attendees today had a direct hand in shaping those recommendations. So the first thing I wanted you to look out for is really kind of what does the council look like now in light of what was recommended in the case for report. And I think you'll see that there are some things that align very well and some things that are not aligned. And the question to look out for in the next year is what is going to be the impact of that? So I think where the 2 things are very aligned are in the functions of the council. You see a lot of what the specific issue and advisory mandate of the council is directly reflected in that case for report. However, what is obviously quite different is the governance and structure of the council, which reports directly to the Minister of Agriculture and Agri-Food and not to an interministerial or interjurisdictional body as had been previously recommended. The second thing to look out for is the council's secretariat function. So a mature national advisory group often has a mature bureaucracy or bureaucratic function to go alongside of it. So that's the second thing that I would like all of you to look out for as we're moving forward on the council. So how agriculture and agri-food itself evolves in light of the council's existence. The third thing is about origin stories. A lot of us kind of started thinking about councils in the days when it was really a municipal food policy council conversation. And this one is obviously very different at the national level and also situated very much within the complex relationships of federalism. So that's also something very tangible and something that we should think about a lot moving forward in the council is that can a concept of citizen engagement and diverse involvement in the food system be operationalized within the constraints of Canadian federalism is something to be seen and to see kind of what those effects might be. The fourth thing is diversity is just a starting point for this council. So I think many of you have seen the list of members of the council. It is a diverse group, but diversity is also a minimum starting point for all of our broader conversations about inclusion and equity. So it remains for the council to operationalize what the council's effects might be. Fifthly, the budget. The Food Policy Council received a lot of attention in budget 2019, and less so, almost zero, I would say, in budget 2021. So to conclude, because I'm already over time now, 7 minutes does go by very quickly, my last message is mostly actually to those of you who are earlier in your career or trainees. I would say, and my recommendation is to watch out for what you wish for, because those very things that you might be writing about, you might be one day tasked with implementing them. And that's the situation that I find myself in now. So I'm happy to take questions outside the panel, and that's my update.
Thank you so much, Catherine. As someone who is just starting my career, that is a very intimidating and also very exciting piece of advice to leave us on. So thank you for joining us today, and thanks for sharing that. Our next is Michael Fakhri here. I just realized at the beginning that I did not see him. Oh, I do see him on the side here. That's perfect. A little late, yeah. Hi, Michael. So thank you so much for joining us today. We're very lucky to have Michael here. He is the UN Special Rapporteur on the right to food, and he's here to provide us the update on the UN Food Systems Summit. He is a professor at the University of Oregon School of Law, and he's the director of the Food Resiliency Project in Environmental and Natural Resources Law Center. So thank you so much, Michael. You can start your 7 minutes now. And I don't know if you were here at the beginning when we said you'll get a little chat pop up to warn you with 1 minute left. Thank you so much.
Sounds good. Great. Thank you, Jessica. And thank you everyone for being here. I think this is my second Canadian Food Law and Policy event attending. So it's just a pleasure to be here. What I'll do is first explain what my role is as a UN Special Rapporteur on the right to food. And then I'll talk about my relationship to the UN Summit, and then I'll explain what the summit is, and then very quickly explain maybe how you can engage with it or situate yourself in relation to the summit. So as the UN Special Rapporteur on the right to food, the United Nations Human Rights Council has authorized me to be the leading independent expert on the right to food. The operative word here is independent. Unfortunately, with independence comes very little resources. So it's a voluntary position. And generally in COVID, it's just me yelling into my computer. I mean, that's what this job has entailed for the most part. My job, but more specifically, my job is to report and investigate what is going on in the world when it comes to hunger, malnutrition, and famine. And I have a very broad mandate. So I don't just report on the right to food violations. I look at broader issues like the political economy of food and food governance. I also meet regularly with national and subnational governments, international civil servants, social movements, trade unions, advocacy groups. So special rapporteurs, there's over 40 of us with different mandates. We often act as the center point for global conversations around particular issues. Now, turning a bit to the summit, in October 2019, the Secretary General of the United Nations called for a food systems summit, which is scheduled to be in this fall, in 2021, this fall, in New York. And he appointed Agnes Kalibata as his special envoy for the summit. And from the beginning, there was controversy. So Dr. Kalibata is a scientist that has led the controversial Alliance for a Green Revolution in Africa, otherwise known as AGRA. And this has been an organization that generally ignores the role of human rights in food systems and sees all solutions to come from high input, high tech solutions. And you see it in the name, this idea of the Green Revolution is built into it. So immediately what happens is over 500 organizations representing millions of people in the food system called foul and were upset that the Secretary General appointed someone with close ties to multinational corporations and mega philanthropy organizations as the leader of this UN process. So the goal of the summit is to be an event that will push the world to transform food systems with a particular emphasis on eliminating hunger and malnutrition. And the Secretary General has called it a People's Summit and a Solutions Summit. The plan is for member states, UN entities, civil society, and businesses to come together to develop ideas on how to transform the world food system. And here I've had two criticisms. One is it's not a personal one of who is leading what, but rather I think when you're at such an important juncture, when everyone knows the food system doesn't work, whether it's because of climate change or the rise of hunger, and then we see in the pandemic how things are worse, I think in such a situation, you should be bringing leaders that bring people together, that are good at finding common interests, and show a real commitment to human rights. So when the Secretary General called it a People's Summit, I think it came, but then the summit has this elitist sensibility in play. It's created some degree of political cynicism. The other concern I've had is this language of multi-stakeholderism. The idea is, well, this is a process open to all stakeholders, but in a food system, everyone's a stakeholder. And what ends up happening is that those with power or with the ability and the time and the resources, especially during the pandemic, they have the wherewithal to engage with the process. So the process is open, anyone can find their way in, but it's really hard to engage, especially if you're one of the most marginalized in the food system. And I think by not using rights-based language in which you prioritize and privilege people in their capacity as rights, if you have this vague multi-stakeholder language, you end up with a process that has the veneer of openness, but is substantively, I think, problematic. So I started my mandate May 1st, so it's been just a titch over a year. In September of last year, the Food Systems Summit Secretariat invited me to be on what's called the integrating team. So this is where all the different people leading the different parts of the summit come together once a month and try and make the final outcome coherent and cohesive. So I'm part of that team. I meet regularly with all the leadership and advise them the best I can. What's complicated is I have to always maintain my independence from the summit itself. Sometimes the Secretariat will put out press releases implying that I'm part of their process. But I always have to remind everyone I'm independent, I'm here to provide advice. And what I'm going to do in the end is I will provide my final assessment of the summit and the summit's human rights record. And I report in this instance to the UN General Assembly, not the Secretary General. So in some sense, it's not that I was invited to be part of this process. It's part of my mandate that I have to be there. So when I arrived to the summit process, the first thing I realized is human rights really wasn't on the agenda. So I spent the last several months, really the last year, trying to get human rights on the agenda, making it a central aspect of the summit. And of course, I appreciate human rights has its own politics, but part of what I was trying to figure out was why. Why didn't a summit that was called by the Secretary General of the United Nations not start with human rights as a defining feature? So, and I can answer that question in the question periods because I see I have about a minute left. So what's going on now? So right now, the summit is done collecting information. That finished May 1st, and they're now trying to collate and organize that information and picking winners around those ideas. There will be a pre-summit in Rome, July 26th to the 28th. It'll be hybrid, so you can participate online if you want. So you could attend the pre-summit. If you want to engage more directly, I encourage you to reach out to what's called the Champions Group. So if you just Google Champions Group Food Systems Summit, it's led by Ruth Richardson. And Ruth actually lives in Toronto, so not far to some of you. And she leads what's called the Global Alliance for the Future of Food. The Champions Group is a good way to find your way in at this stage, I would say, and I can explain what it is. But now listening also to Catherine, I think that's actually the most important place is engaging locally and nationally, because what's missing in the Food Systems Summit is a focus on governance. And I think if you have a bunch of good ideas, but you run them through a bad set of rules and institutions, you're going to get bad outcomes. And right now, the Food Systems Summit has no understanding or theory of governance. It doesn't even have a shared understanding of what is the problem in terms of governance. And it doesn't even have COVID on the agenda. So here we all are struggling in a pandemic in the midst of a hunger crisis. Our communities are tired and weak. So my encouragement to everyone is, you know what? Take care of your loved ones, feed your community, feed your kin, take care of your neighbors. That's everyone's priority. And two, whatever the ideas come out of the summit, there are going to be some good ones, there are going to be some bad ones. Focus on the governance structures you have to make sure that whatever comes out of this event, it's an event after all, not an institution, and make sure that your local and national and regional and international institutions and mechanisms of governance are strong. Thank you very much. I look forward to our conversation.
Thank you so much, Michael. I know that a lot of people who are on this call and attending this conference are closely following the summit and your tenure in general. So thank you so much for being here. And we're definitely going to be following those developments. The next speaker is Angela Delia Decembrini. She's going to present the update today on Indigenous law. And Angela is a lawyer with First Peoples Law based in Toronto. We're very pleased that she accepted our invitation since she played a significant role in representing Mi'kmaq commercial fishing rights last year and is very well placed to give us this update today. And more broadly, Angela represents Indigenous peoples in negotiations with all levels of government and with the private sector. So thank you, Angela, and we look forward to this.
Thank you, Jessica, and thank you for the introduction. So as Jessica mentioned, I'll be speaking about the Migma self-regulated fisheries in Atlantic Canada. And I think the program title for this event, Governing Territorial Food Systems, Legal Obstacles and Opportunities, provides really good context for this discussion. For many Indigenous peoples, maintaining access to traditional food sources is connected to their relationship with the land and environment, the exercise of their Aboriginal title rights and treaty rights, and the continuity of their cultures. So I think it's important that we keep that in mind as we discuss the events that have transpired over the last 8 months or so respecting the Mi'kmaq fisheries. For today's discussion, I'd like to provide some context for the rights at issue, briefly address some of the misconceptions or key issues about Mi'kmaq commercial fishing rights that have arisen in the last few months, and touch on some of the obstacles and opportunities that have arisen in connection with the exercise of these rights. So beginning with the right, at the heart of this ongoing conflict is really a fundamental misunderstanding about the nature of Mi'kmaq commercial fishing rights and the Crown's failure to implement those rights. The Mi'kmaq have constitutionally protected rights to fish and to sell their catch. And these rights are rooted in practices that have sustained the communities since pre-contact. They're acknowledged and set out in peace and friendship treaties that were entered into between the Mi'kmaq and the British Crown in the 18th century, and they were recognized by the Supreme Court of Canada as constitutionally protected in the 1999 Marshall decision. And specifically, that decision, Marshall recognized that the Mi'kmaq have a constitutionally protected right to fish for a moderate livelihood. This means that in addition to their right to catch fish, they have the Mi'kmaq have a constitutionally protected right to sell the fish they catch in order to support themselves and their families. And this is the right that the Mi'kmaq fishers in Nova Scotia are exercising through their commercial lobster fisheries. Since Marshall, the Crown has been reluctant to engage in any meaningful good faith negotiations with the Mi'kmaq to implement these rights. And it's against that backdrop then that the Sebeganegati First Nation in September of last year commenced a lobster fishery regulated in accordance with their own fisheries management plan. In response, as we know, members of the non-Indigenous commercial fishery organization took the position that the Mi'kmaq were not authorized to launch their own self-managed fishery because the fishing season was closed under federal law. And they accused the Mi'kmaq fishers of operating an illegal fishery, reacting, again, as we know from the media, with violent attacks and acts of vandalism. So with that context in mind, I think it's important to address some of the misconceptions or key issues that have arisen in response to the Mi'kmaq fishery. The first being this claim of an illegal fishery. As explained, the right of the Mi'kmaq to engage in the commercial lobster fishery is based on their constitutionally protected Aboriginal and treaty rights. These rights are not dependent on the Crown's legislative authority. Canadian courts, including the Supreme Court in Marshall, have held that the Crown may regulate the exercise of these rights. However, in order to do so, the Crown must demonstrate that any regulation is justified for conservation or other grounds of public importance. So it's not an illegal fishery, it's a fishery that has been established in accordance with the Mi'kmaq's constitutionally protected rights. The next issue that I want to touch on is the lobster conservation concerns. Much of the opposition to the Migma fishery has focused on potential negative impacts to the lobster. And in March of this year, the federal government announced that it would only recognize Indigenous moderate livelihood fisheries that operate within federally regulated commercial fishing seasons. And their justification for that approach seems to be, or is said to be, based on conservation concerns. However, the validity of those conservation concerns has been questioned. And I think it's really important to note that the Migma have been very clear from the start that they take conservation very seriously. They're regulating the fisheries in accordance with their fishery management plans, which incorporate conservation and enforcement measures. And just recently, Sebeghinegedi announced that it will be participating in a joint conservation study to collect data to monitor the impact of its fishery on the lobster stocks. So while the Crown can limit Aboriginal fishing rights for conservation purposes, that they're to be justified, there really must be a legitimate conservation concern. The last issue is the Crown's prosecution of buyers. So in the days following the opening of the Sebeghinegedi fishery, Canadian governments issued media statements saying that they would prosecute anyone who purchased fish caught as part of the Migma fishery. I think the key issue here is that any steps taken by the government to deter buyers from purchasing lobster from Migma fishers is a direct threat to the Migma commercial fishing rights. In order for Migma fishers to exercise the right to sell their fish to support themselves, they must have access to a commercial market for that fish. Without buyers, they can't exercise the right. So rather than honoring the treaties, I think the Crown's prosecution of buyers has only further undermined the Migma fishing rights. So then, I guess to wrap up, going back to the theme of the program, I think the concept of obstacles and opportunities is an interesting one at play here. In addition to exercising their constitutionally protected fishing rights, the Migma are also exercising their inherent jurisdiction to establish and regulate their fisheries in accordance with their own laws. Shortly after the launch of the Migma fishery, the Sebeghinegedi entered into talks with DFO regarding the implementation of the moderate livelihood fishing rights. And there was much optimism that these talks would lead to the negotiation of a collaborative approach to fisheries management that would recognize Migma commercial fishing rights and Migma jurisdiction to regulate and manage those rights. Unfortunately, those talks broke down in December of last year. And I think Canada's recent announcement that it will not license any treaty-based fishery unless it operates within the federally regulated commercial seasons creates a further barrier to the possibility of this type of collaboration and really perpetuates this ongoing policy of denial of Indigenous rights. And here I'd like to come back to that connection I spoke about at the beginning about between access to traditional food sources, the land, the exercise of Indigenous rights, and the continuity of culture. Because of this interconnection, this relationship, in addition to undermining the ability to exercise their Aboriginal and treaty rights, Canada's approach to the Migma fisheries also threatens their economies, their livelihoods, their trading relationships, and kinship systems, and their traditions, their culture. So I think it's maybe not surprising that in response to Canada's announcement, Sebeghinegedi First Nation has advised that it will resume its self-regulated lobster fishery, I believe starting in June, outside of the federal commercial season. So that's it for now.
Thank you so much, Angela. This is something at least I and I'm sure many on the call have been following in the news. So it's really great to have you here to give us the update on both your experience representing the Migma and also the situation as it is now and what we can expect to see. So thank you so much for that. And our next update is on trade law. In the program, you'll see it was supposed to be Carmen Francis, who couldn't be with us today. So Martha Harrison stepped in. Thank you so much, Martha, for being here. Martha Harrison is a partner in McCarthy Tétrault's International Trade Law and Investment Law Group. She's well positioned to provide the update on trade law as she offers a full suite of international trade and investment services in her practice. And she advises on all trade-related issues, including customs law, import-export controls, and treaty compliance. So thank you so much, Martha. Take it away.
Thanks, Jessica. I appreciate it. And apologies, I'm not Carmen, as Jessica said, but I will do my best to fill her shoes. So thanks everyone for having me. I'm delighted to be here. When Jessica and I talked about the opportunity for me to sort of pinch hit today and talk on trade, I turned my mind to a couple of different events that I've seen happen over the last year since the last summit where we did a talk. And I think, in my mind, there were two themes that really came to the forefront. And the first is the increased importance on international regulatory compliance with respect to trade and food in particular. And the second piece is how digitization and digital trade is really becoming a very important tool to increase trade in food, trade in agri-food, and all things related to trade input units, particularly as it relates to opportunities for developing countries to access more markets. So in the context of regulatory cooperation, I thought what I would do is give a very high-level overview of a few of the key features in what we used to call the new NAFTA. I think we've finally graduated to either the USMCA, if you are in the US, or the CUSMA, as we call it in Canada. And there are some interesting features of the trade agreement, the new trade agreement, that provide for and prioritize regulatory cooperation that will directly impact North American trade in food products. So to start, if I could classify these themes, again, it would be emphasis on regulatory cooperation and emphasis on streamlining trade. One of the chapters is called Sanitary and Phytosanitary Measures. It's chapter 9. And this is a modernized chapter from the NAFTA that reinforces and builds on provisions that the original NAFTA had with respect to the extensive trading relationship between Mexico, Canada, and the United States. And it prioritizes food safety, animal, plant safety as well. It certainly maintains the rights of the signatories, the rights of the parties to develop measures to protect human health, animal health, and plant health. But the chapter requires that these measures be really science-based. In other words, the measures that could have a restrictive effect on trade in foods need to be supported by science as opposed to pure political policy. And the chapter also introduces new obligations relating to the analysis and the use of science and risk analysis in creating new rules. It provides for a compatibility of SPS measures as between the three countries, and speaks to an equivalence, a regulatory equivalence as between the three countries as well. And the hope is that these new rules in the chapter will increase trade opportunities, primarily through the three territories, but really looking for small and medium-sized enterprises to more easily access trade in food. And the second chapter I wanted to mention is a brand new chapter in the CUSMA that didn't exist in the NAFTA. It is called Good Regulatory Practices. This is a new chapter, as the name would suggest, that it's looking to further emphasize the goal for the three countries to work together to create transparent regimes and trading rules that are predictable and aligned with one another to the extent possible. The Good Regulatory Practices chapter is designed to foster what I would call sort of stronger trade relationships, as well as protecting individuals in each country from products and food products that may be harmful. There is a recognition in the chapter for voluntary regulatory cooperation and for investment among the three parties. And effectively, it again, like the SPS chapter, still allows individual states in the NAFTA signatory countries to develop restrictions on food trading and related trading where they are based in science. And the agriculture chapter under the NAFTA, I'm not proposing to spend too much time on it because it could be an entire session in and of itself, but just wanted to mention one key piece. There is a new annex in the agriculture sector on proprietary formulas for prepackaged foods and food additives. And this annex reflects efforts to sort of increase the ability for states to require companies to share information on ingredient mix and food additives in order to evaluate whether they are safe, but it also provides for the protection of that confidential information. And so parties are allowed to request information on proprietary formulas as long as there is a legitimate objective, and again, based in science and research, etc. Now, critics of this new section propose that it might, the special confidentiality rules might make it more difficult for citizens to acquire information on new prepackaged formulas and food additives. Whether that is the case remains to be seen. We're still quite new in the implementation of the agreement, but it's an interesting piece that directly impacts the prepackaged food sector. And I just thought I'd spend a quick minute on digital trade. So digital trade is actually a chapter in and of itself under the USMCA, but those rules relate to sort of the obligations to provide certain disclosures on internet streamings, et cetera. And I'm talking about digital trade that really relates to digital tools that can increase opportunities for trade in food in particular. We certainly see Canada taking digital tools as a measure to facilitate regulatory compliance. For example, under the Canadian Safe Foods for Canadians Act, the CFIA has an online licensing system where certain purveyors of activities like importing can apply online for their import license under the Act, et cetera. And that really provides an opportunity for quick compliance for the licensing activities. But I'll end with one particular example of digital trade that I found while I was kind of researching this idea and preparing for today. And here's an example of an actual digital tool that has been developed primarily for African food sector developers and exporters. There is a product called Plant Village that was created a few years ago, and it's an online platform that provides open access to science-based advice on crop health. It has now millions of subscribers across the African continent, and it really enables those subscribers to learn and diagnose potential crop disease issues before their point of export and during crop growth. And the objective really is to provide affordable technology to democratize access to information on crop growth and food distribution around the world. And the result of this particular digital tool, it as an AI assistant, an artificial intelligence assistant, has demonstrated that the number of diagnosed diseases for crops that for members that are using this tool has increased, which has linked to better outcomes in terms of crop health. And very importantly, it's directly linked to an increase in some areas, a rather dramatic increase of international trade in food, including trade to developed countries, which is one of the goals of this digital tool. So I'll leave it at that, but I do feel that digital trade tools will become more and more important moving forward for streamlining opportunities for developing countries, as well as opportunities in the private sector for multinational corporations.
Thank you so much for that, Martha. I had not thought about the significant interplay between digital trade and food systems. So thank you so much for mentioning that in your update. We'll look into that further for sure. The next update is from Annalise Weiler. Thank you so much for being here. She's going to give us the update on workers' rights. She's an assistant professor of sociology at the University of Victoria where the research she's done on struggles for migrant justice and decent work across the food chain make her well placed to speak to this year's updates in workers' rights. Thank you so much, Annalise.
Great, thank you so much. Could I get a quick thumbs up that people can see my slides?
Yes, we can see them.
Wonderful, thank you. A broad theme that we have seen over the past year is that governments in Canada have repeatedly prioritized policies that favor powerful employer interests in agriculture and agri-food. This has often occurred at the expense of working class people who do life-giving work across the food chain. In some cases, putting profits before people has cost workers their lives. And in particular, the food chain workers who have borne the biggest costs in the pandemic are often racialized, migrants and recent immigrants, and women. Although there are many issues that I could discuss in terms of workers' rights across the food chain in Canada, today I'll just focus on two. The first one that I'll discuss is the intensification of risks facing migrant workers, particularly migrant agricultural workers, and public pressure for paid sick leave. Migrant workers from the majority world are employed across Canada's food chain. This includes seafood, food service, meat packing, but particularly in agriculture. Migrant farm workers make up about 20% of employment in Canada's agriculture, Canadian agriculture, and much higher in provinces like BC, Ontario, and Quebec. Migrant farm workers come predominantly from Mexico, Jamaica, and Guatemala. And when the pandemic hit last year, employers successfully lobbied for migrant farm workers and migrant workers in general to be exempt from international travel restrictions. The move was extremely hasty, and many advocates and researchers warned that there were not enough enforceable protections already established before workers arrived to ensure workers' rights, but their warnings were largely unheeded. And the existing structure of Canada's seasonal agricultural worker program has really amplified the risks that migrant workers have faced during the pandemic. Workers' permits are tied to employers in the seasonal agricultural worker program. So it's very difficult for workers to simply leave a workplace that is dangerous or substandard. They can be threatened with repatriation if they raise concerns about workplace health and safety issues, as we saw in the case of Gabriel Flores, a farm worker who was in an outbreak in Ontario this past year. Employers also mediate workers' access to services like housing as well as healthcare, and the various jurisdictions that are responsible for migrant farm workers' rights have really failed to take coordinated leadership. For example, last year, the federal government launched a consultation for national migrant agricultural worker housing standards. This was a very welcome move. But in previous years, employers had lobbied against the establishment of this kind of standard. Bureaucratic inertia has meant that the process of developing that standard has been extremely slow. And even announcing one or two preliminary national migrant farm worker housing standards in 2021 could have made an enormous difference for many workers' lives, such as a prohibition on bunk beds for grown adults. In an interview with the Globe and Mail, one migrant farm worker in Ontario who tested positive for COVID-19 said, quote, "We notified supervisors when people were falling ill and they didn't do anything. They treated us like animals." Some of the issues that led to outbreaks in agriculture this past season and this season included overcrowded housing, lack of access to PPE, and inadequate inspections. In the first wave last year, about 12% of migrant farm workers in Ontario contracted COVID-19. 3 migrant agricultural workers died last year from COVID-19. Grassroots organizations like Justice for Migrant Workers have called for a public coroner's inquest into these deaths, but thus far there has only been a confidential investigation on the part of the coroner. Moving into this year, outbreaks on farms have continued into 2021, and vaccines alone are not enough to address the health and safety issues that are facing workers. Since mid-March of this year, already there have been 5 deaths of migrant farm workers in Canada, with causes yet to be announced. Moving to my second update, I want to highlight public pressure for employer-paid sick leave, which most Canadians have not had until basically up till this week. Many of the outbreaks that we've seen among food chain workers over the past year have been among low-wage, non-unionized workers in places like industrial bakeries. If a worker gets sick, it is very difficult to take unpaid time off if they are living paycheck to paycheck. And to be clear, a lack of paid sick days is not the only reason that we're seeing outbreaks in these types of settings, but it is an important part of the picture. And so who is most affected by a lack of paid sick leave? We're talking about low-wage workers who are often women, Indigenous, racialized, recent immigrants, and migrants. And there has been a massive outpouring of public support for paid sick leave, also from the labor movement, from healthcare providers, public health leaders, who've been campaigning quite heavily on this issue. So why the holdup? There has been strong industry pushback against paid sick leave, particularly from corporate lobby groups who do not want businesses to shoulder any costs and who want paid sick days to be sunsetted, which is kind of a corporate euphemism for killing paid sick days after the pandemic. Low-wage workers often work for corporations, and it's worth noting, by contrast, living wage employers have advocated for paid sick days. So this is something that many living wage employers do want to see. Although the Yukon offers a better model, many of the provincial paid sick leave programs that we've seen announced in Ontario, BC, and elsewhere have been extremely disappointing. But without organizing and public pressure, we wouldn't have any paid sick days at all. So in short, organizing does realize substantive changes. I'll conclude on this thought. In a post-pandemic world, sustaining and leveraging any gains in food chain workers' rights, such as paid sick days, will depend on persistent organized pressure on multiple fronts. Thanks so much for your time, and here's how to get in touch with me.
Thank you so much, Annalise. I've been working closely with restaurant workers in Montreal since the beginning of the pandemic, and I know how important the fight for paid sick leave days is for them. So thank you so much for highlighting that in your presentation. The next update today is going to be about advertising, labeling, and marketing. Glenford Jameson is giving this update to us today, and he is a founding member of the Canadian Association for Food Law and Policy and has been involved with the organization of this conference since its inception. So thanks, Glenford, for bringing us all here today, directly or indirectly. And he is a lawyer at GS Jameson and Company, focusing on corporate and commercial and regulatory matters in food. He also teaches Canadian food law and regulation at Michigan State College of Law. And take it away, Glenford. Thank you.
Awesome. Thanks so much, Jess. And for everyone on this panel, it's funny, Martha said she was pinch hitting, but from my view, this is just a murderer's row of food law talent. So thanks everyone for being here and for everyone participating. This is phenomenal. I've got 6.5 minutes, so I'm going to try and make this brief. I really just today want to talk about marketing and labeling. I'd like to talk about it with a bit of sort of a stakeholder analysis in the beginning, and then the regulatory roadmap going forward and some consultations that have occurred since the last conference, which was in 2019. It's important when we think about the regulated community to think about where the consumer is, where is the consumer sitting, and how are they doing. 2020 and 2021 have been an interesting time. And Twitter and social media has been interesting because it sort of allowed us to explore a lot more of what's out there in terms of the regulated community and consumers. Of course, I mean, the regulator and the regulated community are working in a good faith effort to ensure product, sorry, my slideshow's going a little funny here, is working to go a little, is working in the best interests of public safety and public health. That being said, although right now seems like a low point, in 2020, we were having Lysol reach out and say, essentially, you should not drink our products. In 2018, we were still going through this sort of thing. And so maybe the consumer isn't such a moving target, even though it may feel like it is on a day-to-day basis. Tech is a bit of a different thing, and the regulated community, to say industry, is changing quickly. I think that there are a lot of changes that we need to be aware of, both in terms of how information is being broadcasted or spread, as well as how food is being sold. I think that there are two core points that have really developed since 2019 that were foreseeable in the last 10 years, but have really sort of taken off. So the first is social media has changed effectively how we market and advertise and buy and sell food. And we've been thinking about that for a long time. And Ad Standards in Canada has done a lot of work to say, look, we need to say hashtag ad in the US, or here's our code, here's how you get clearance if you're doing this in an official way, and here's what product placement looks like. TikTok is a different beast. It is remarkably well integrated for e-commerce. It typically takes people direct to Amazon, Shopify, or Alibaba stores, and the barrier to entry is virtually zero. And so what we're seeing in some new social media areas is a very aggressive and unpoliced food marketing that runs contrary to a lot of Canadian food law, and specifically natural health product regulations, and a very difficult platform to police. Things happen very quickly. And so the market is really changing. Likewise, we have large federal food safety and food regulation laws in Canada, the Food and Drugs Act and regs, and then the Safe Food for Canadians Act and regs. And the proliferation of Shopify, Amazon stores, and the ease of order fulfillment, even drop shipping, even in the food sector, presents a very unusual problem, in that if you're doing everything that you should be doing as a local store and trying to serve a local market, if you go to e-commerce, typically you are crossing borders, and that brings into play the Safe Food for Canadians Act and regs, which all of a sudden triggers licensable activities and the requirement for filings and traceability rules and things that are very healthy, but they're challenging. So with that, then where are we at with the CFIA? How's the CFIA doing? And I know there are some CFIA folks on this call, but the CFIA has their hands full. As of July 15th of last year, any food business that crosses borders with food requires a CFIA license. They were required to file for that and put a preventative control plan together and put together traceability documents and a number of other things. But what it primarily means is that for a lot of businesses that have never really had much in the way of regulation, suddenly now they're experiencing a significant degree of regulation. And at this moment, we're not seeing a lot of license cancellation. We were seeing a bit of that at the very beginning when meat plants were being licensed. But this moment, there is a major change in the way that food is bought and sold in Canada, which is remarkable. Adapting to COVID, obviously a huge deal. Last year, CFI suspended low risk food safety enforcement. That's come back on. Like I said, issues relating to consumers and where their heads are at, and then technology and how we buy and sell food is changing. It seems to be like we're heading into an era of greater scarcity. The European Food Fraud Bulletin would suggest that there's a lot happening there. And all that to say, the CFIA's hands are very full. Health Canada and the CFIA have set out the following roadmap. And this roadmap has been very frustrating to communicate to clients. which is to say, just to read off the slide, sometime in what was supposed to be 2020, now is 2021, we are awaiting pre-publication of regulatory changes to test marketing authorization changes. Those have been in the Gazette now and they're coming. But container sizes and class names are supposed to be streamlined for standards. And we haven't heard anything about that since 2019. At the end of this year, food labeling modernization is supposed to take hold. This is a process that was started in 2016. It involves a new nutrition facts table that you've probably seen, ingredients rules, sugars grouping, a lot of really important public health measures. That's still due to come into force in 2021 due to supply chain interruptions and just an understanding of what COVID is doing. CFI has essentially said 2022 is going to be a year where we encourage compliance and not a year where we go into enforcement. Likewise, single-use plastic ban is coming. So from a packaging perspective, there's a massive change underway that we're really seeing right now in this takeout universe in which we live that is changing what plastic bags look like and what single-use cutlery looks like. And in some prepackaged products, what compounds can be used in lieu of compounds that are difficult to recycle. And then looking further into the calendar, again, 2022, this is on a roadmap, but it's not necessarily something that has been read into the Gazette or we have true regulatory changes. We are expecting updates to date marking rules, company information labeling, country of origin labeling, that's coming up. In 2022, we'll start to see actual enforcement of food labeling modernization rules, streamlining to some commodity rules, and then front of packaging labeling implementation, which is something that public health folks at the federal level have been working on for essentially 10 years. And we've seen the rest of the world or the rest of the developed world really take hold on either voluntary or mandatory public health or front of package labeling. So quite a bit that's moving right now. It's been difficult to advise industry when doing a product review because there's so many moving parts. And so something that was really wonderful to see from CFI and Health Canada in the winter was a consultation on a proposed joint policy statement on food labeling coordination. Effectively, what this says is we think as a regulator, I'm speaking as though I were the CFIA right now, it would be helpful for everyone if changes only came into play every 2 years or so. And me as a lawyer in advising clients, it would also be very helpful to say, look, I'm going to review this product. It's going to be roughly compliant until 2024. And then we can review it again for 2026 and we have some certainty. This has been a difficult time for any entity that markets products in Canada because we have been moving timelines and we've been very aggressive in adapting policy. At the same time, we've been trying to create space for the effect of COVID to supply chains and so on. There was a consultation this winter on plant-based protein and simulated meat nomenclature, which is really interesting. Canada has simulated meat regs that were set out in the 80s that ensured that simulated meat would have the same nutritional fortification that the regular meat would, and that's made it very difficult for some plant-based protein products to enter the market in Canada. And likewise, the universe of plant-based protein products is far more diverse than it was in the 80s, as you might imagine. And so there's been a review of the guidelines, but not actually the regulations on simulated meats. And then lastly, just to end this quick update, Canada historically has stood out for its trading partners in not requiring a ton of due diligence when it comes to made in Canada, the use of made in Canada as a term. And so what we're seeing now is a change where if you're using made in Canada as a term, you're really going to need to have all or substantially all of the process occurring in Canada or the ingredients to be Canadian. And that arose from an issue related to, it was a CBC marketplace piece that I worked on where apple juice from concentrate was largely coming from Asia or from Eastern Europe and having water added to it and being marketed as a made in Canada or potentially a product of Canada, which is a little silly. Anyway, that's our update. Thanks so much for having me. And all right, let's go, Jess.
Thank you so much. Thanks so much, Glenford. I definitely share your sometimes confusion and overwhelming feelings when we're trying to advise clients on labeling and all the moving pieces there with the especially with the like new front of package labeling that's going to come out. So thank you so much for highlighting that. And it was definitely a tall order to fit it all into 7 minutes. So good job with that. We're going to move on to the next update. Also, I realize we have 30 minutes left. So I think the original format of this panel where you're all going to get 2 minutes at the end to answer a question was just too ambitious. I'll probably give you all like a one sentence answer at the end. So we're just going to adapt as we go. I think 7 minutes was a bit too short, and all these topics are so interesting. I don't want to cut anyone off. It's going so well. So we're just going to kind of keep moving through and figure this out at the end. So Selena, thank you so much for being here. Selena Lee Anderson is here to give us the update on animal law. She is a partner in our Vancouver office and practices environmental, regulatory, and Aboriginal law. And she regularly advises on matters relating to policy development, compliance, and industry standards in the agricultural sector. So thank you so much, Selena.
Thanks very much, Jessica. Appreciate the kind introduction. I'm just going to launch right in, given the time constraints. So as Jessica mentioned, my update is to just provide a quick update on the state of animal law in Canada today. And I'll just kind of highlight some recent legislative developments and cases of interest that this kind of fast-moving area is evolving. So it's been 15 years since Dalhousie Law School first offered a course in animal law. And today, about half of Canadian law schools offer a similar course. Animal law is on the rise, both in Canada and throughout the world. So the legal evolution around our treatment of animals and how we think about them really reflects a shift in cultural and social attitudes, as well as a growing body of research around animal sentience and welfare. In Canada, most animal protection laws are established at the provincial level. This is because under our Constitution Act of 1867, provinces are responsible for making laws with respect to property. And since animals are still considered property at the moment under the law, they fall primarily within provincial jurisdictions. So this has resulted in a patchwork of laws, as you can imagine, as in many other areas of law, which makes it sometimes a challenge to enable a consistent approach to animal protection. That said, animal protection laws also exist at the federal level in the criminal code, in regulations for the transportation of animals, and in regulations for humane handling and slaughter at abattoirs that are inspected by the CFIA. So just taking a 60,000-foot view, how does Canada rank in terms of its overall regime to protect animals? In the 2020 edition of the Animal Protection Index, which ranks 50 countries around the world according to their legislation and policy commitments to protecting animals, Canada received a D, alongside other countries including Tanzania, Peru, Australia, and the United States. In the assessment, each country was given a rank from A to G, and while no country got an A, to put things in perspective, the UK, Sweden, Denmark, Netherlands, Austria, and Switzerland were among the countries that received a B score. The reason for Canada's low grade is mainly because of its inadequate legislation to protect wildlife in captivity, as well as working farm research and companion animals. In terms of recent trends, 2019 was a very significant year for animal law in Canada. One of the main pieces of legislation passed in 2019 was the Ending of Captivity of Whales and Dolphins Act, which effectively outlaws the keeping, breeding, and capture of cetaceans for public entertainment, as well as participation in the international trade of these animals. In 2019, Canada also became the first G20 country to ban the import and export of products from shark finning, which is a cruel practice that affects an estimated 73 million sharks every year. Previously, Canada was the largest importer of shark fins outside of Asia. 2019 also saw the first substantive revisions to the criminal code relating to cruelty to animals in more than half a century. In particular, the criminal code was amended to close a loophole relating to the offense of bestiality and to strengthen the code's provisions dealing with organizing and keeping animals for animal fighting. The amendment that explicitly now prohibits all sexual abuse of animals was prompted by a 2016 decision from the Supreme Court of Canada, which found that the criminal code provided too narrow a definition of bestiality, which served to undermine the legislative protections for animals from cruelty and abuse. In addition, in 2019, the Health of Animals regulations were amended to reduce the maximum length of transport of animals without access to feed, rest, or water for certain classes of animals. More recently, building on the cetaceans legislation, back in November of 2020, former Senator Murray Sinclair introduced Bill S-218. This is also known as the Jane Goodall Act. The purpose of the bill is to ban new apes and elephants from entering a life of captivity unless it is in their quote unquote best interests. So this acknowledges that animals have inherent rights. The bill would also require a permit for the import or export or interprovincial travel of great apes, elephants, and other certain non-domesticated animals. Another key provision of the bill includes establishing limited legal standing for the protection of animals. That means that courts would be able to pronounce orders to improve an animal's living conditions or have them move to a better living situation. The bill is groundbreaking in its nature and would fundamentally alter the landscape for animal protection and legislation in Canada if it's passed. Just last month, the federal government proposed amendments to the Canadian Environmental Protection Act, and really most of the changes kind of focus around the management of chemicals and substances in the country. And one of the proposed changes is to recognize the need to reduce the reliance on animal testing when assessing substances. So this would encourage federal departments to promote the development of alternative methods and strategies to animal testing. At the provincial level, in November of 2020, the Ontario government established an advisory panel of animal experts and stakeholders to develop new regulations under its Provincial Animal Welfare Services Act, also known as the PAWS Act, which came into force in January of last year. The PAWS Act introduces Canada's first provincially funded and government-based enforcement model for animal neglect and abuse. When it comes to animals farmed for food, conditions are generally governed by voluntary industry codes of practice. Over the past couple of years, we've seen the emergence of what have been referred to as agricultural gag laws, also known as ag-gag laws. Ag-gag laws are seen as a response to efforts by whistleblowers, undercover journalists, and animal welfare organizations to expose operating conditions in meat, egg, and dairy farms. Ag-gag laws are controversial because they make it illegal for concerned citizens to document conditions or to interact with animals in transport trucks, or for whistleblowers or investigative journalists to get a job on factory farms. Ag-gag laws are relatively new in Canada, but not new. They first emerged in the US in the 1990s, and there are at least 16 states that have adopted such laws. Alberta passed Canada's first ag-gag law in November of 2019 by amending its existing trespass laws. Their ag-gag law makes it illegal for a person to enter a farm or slaughterhouse under false pretenses. So, for example, a failure to disclose on a job application that the applicant is connected with an animal protection organization would be considered a false pretense. The legislation sets fairly steep fines, a maximum fine of $25,000 or 6 months jail for an individual, or a maximum fine of $200,000 for an organization. Ontario passed its own ag-gag law in June 2020 under the Security from Trespass and Protecting Food Safety Act. And the Ontario law makes it a crime to enter an agricultural facility also under false pretenses and to either interfere or interact with animals in transit. In March of this year, Animal Justice, the NGO Animal Justice, filed a lawsuit against the Ontario government challenging the constitutionality of a number of sections of the Act. In particular, Animal Justice is challenging the Act on the basis that it violates freedom of expression, freedom of the press, as well as peaceful assembly. In the US, similar laws have been found to violate the First Amendment right to free speech. In 2019, Kansas, which was actually the first state to pass an ag-gag law in 1990, struck down their ag-gag laws on the basis that they violate the First Amendment rights. And in 2017, the US District Court in Utah found that restrictions on gaining entry to a facility under false pretenses is overly broad and therefore unconstitutional. Other provinces have also been in on the game. Prince Edward Island in December of 2020 passed legislation to amend their Animal Health Act, and it essentially establishes steep fines for anyone who enters a farm or slaughterhouse without permission in a manner that could expose animals to disease or cause them to escape. The PEI legislation doesn't contain the same false pretense language similar to Ontario and Alberta's ag-gag laws, but contraventions of legislation could result in maximum fines of $50,000. And for organizations, the maximum fine is $100,000, and its directors face potential imprisonment for up to 6 months. Manitoba and Quebec as well are both looking to introduce similar ag laws. So as we can see, animal law issues are gaining momentum. Beyond legislation, I just wanted to highlight one case which made it all the way to the Supreme Court of Canada, although it was denied leave to appeal. And this case was the case of Punky Santix, which came to be known as Canada's Every Dog. In January 2020, as I mentioned, the case reached the Supreme Court of Canada, but was unfortunately refused leave to appeal. Punky was a young Australian cattle dog that was designated a dangerous dog after biting a stranger at a Vancouver park in 2017. Punky's designation was appealed to the BC Court of Appeal, and at issue was a legal test that was applicable to destruction orders for dangerous dog applications. Punky's appeal was unsuccessful, but at the last moment, a BC Court of Appeal justice granted leave to appeal to the Supreme Court of Canada. Justice Peter Wilcox stated that Punky's legal team had some arguable points, and although their chances of obtaining leave to appeal to the Supreme Court were slim, they were not negligible. So the court allowed Punky to live while his legal team filed an application to the Supreme Court of Canada in September 2019. And his legal team argued that his case was of national importance and that it was imperative for animals to have access to justice. Punky was sadly euthanized after the Supreme Court denied leave to appeal, but his case will have lasting impacts. Punky's case addressed the importance of provincial courts' powers to order conditional orders in animal destruction cases, as well as to request clarity for appropriate tests in animal destruction cases. At the heart of Punky's case were the core principles of justice, animal welfare, and the struggle for animals to be recognized as more than property in the eyes of the law. So on that note, I'll hand it back to Jessica.
Thank you so much, Selena. I had no idea that there was so much development over the last year in animal law, and I know that a lot of people on this call and who are attending this conference are very closely following the developments in the ag legislation. So thank you so much for your overview of those developments. And I'll move to the next presenter. This is an update on intellectual property given to us by Marcia Cadogan, who is the practitioner chair of the Canadian Association for Food Law and Policy, and also one of the organizers of this conference. So first, thank you, Marcia, for participating in the association and in the conference. And Marcia is an international intellectual property rights lawyer at MSc Intellectual Property and Technology Law. She works with a range of different types of IP, including trademarks, GIs, and design rights. And thank you so much, Marcia. Take it away. Marcia, you are on mute.
Okay, there I go.
Yes,
great.
We can hear you.
Jessica, thank you for having me being a part of this panel. It's really great to be here and to be hearing all these really interesting updates concerning the food system and food law and policy. I'll quickly talk about trade secrets and what it means for food and beverage manufacturers in Canada. I know that we're pressed for time, so it will be really high level, and I won't even go through all of my slides, although I have about 5 slides to go. So the change really came about last year, really because of CUSMA, and the trade secrets really relate to that information that is a secret to a business, and it's a secret because it has economic value, and some jurisdictions will refer to it as it's commercially relevant to the business. And it's also information that is not only not known by a lot of people, but reasonable efforts is made by the food and beverage manufacturer to keep that information secret. And so it's really the relationship with trade secrets to intellectual property. It's kind of interesting. It's one of the only, I think it's the only form of intellectual property, quote unquote, that it's not registrable as IP. So unlike trademarks, geographical indications, plant varieties rights, and so on, it's not registrable, but it's protectable as intellectual property if the criteria is met. And so at the international level, it is recognized in the TRIPS agreement, which is the agreement on the protection of intellectual property rights. under Article 39.2, where it states that businesses, it doesn't really say businesses, it says persons, but for our purposes today, food and beverage manufacturers should have the right to protect information from being disclosed, whether this be accidentally or intentionally by others. And so the TRIPS agreement, that specific provision does define trade secrets, but and that is great, but it also gives jurisdictions the flexibility to decide how they recognize it, because it says members should have the possibility of recognizing trade secrets. Now, the relationship with trademarks, if you think about it really well, is that if to a food and beverage manufacturer here in Canada, there was a Supreme Court case with Clamato juice, also with Hellmann's mayonnaise. If you think about the taste also of Coca-Cola, Pepsi, it relates to that what distinguishes your food, your product, your beverage from others. So it could be the taste or the look. And so it goes to brand value. And we know that if you want your trademark to be sustainable, not only in Canada, but also in, globally, the brand value is very important as well. And so if this information is misappropriated, it leads to unfair competition, which is also something that is recognized in IP as something not to be encouraged, especially if it's unfair business practices. So we see that connection right there. Now, the interesting thing in Canada, before last year, it was actually recognized or not on a case-by-case basis. It was very contextual. You went from one extreme where early in it was 1999, the court ruled that no, there was no misappropriation of trade secret, because even though the same information was copied, the product was different from the manufacturer's own product. Now, the change really came about last year because of CUSMA, where Canada, the US, and Mexico, one of the commitment is that they do have to have trade secret legislation. However, that legislation looks as a part of their protection of intellectual property and confidential information that is worthwhile to proprietors. And so, I'm sure this was really a US initiated endeavor, because the US has a federal trade secrets legislation under a Defend Trade Secrets Act. They also have specific state legislation as well. But the world is kind of moving closer to this trend because it's very well recognized in the European Union as well. Now, the interesting thing about what we're doing here in Canada is it's recognized under the criminal code, so it's criminalized. And for our purposes today, I'll focus very quickly on the last step and what we need to tell our clients and as to what are reasonable efforts. How can you ensure that you're making that reasonable efforts to keep your secret a secret? Because if your trade secret is not a secret, it's lost, and then there is or under civil remedies as well. And so for the, I don't know how many minutes, correct? Okay, so I'll just go on. And so for the food and beverage industries, what we have to be mindful of is what are reasonable efforts. And these are criteria listed that not only should the information be not well publicized, not well known, has an economic value, but needs to be protected. Reasonable measures need to be taken. What are these measures? And you find that across jurisdictions, this differ. And so what I often tell my non-disclosure agreement that covers to ensure that it's not only seen as protectable by one party, but by others as well. Within the business itself, you can also, I won't go through all of these, but I'll just quickly pinpoint having a phased disclosure rationale. So not everybody needs to know that information. Make it be known on a need to know basis, because that lessens the chance of the trade secret losing its protectability as a trade secret. Also ensure that you're periodically reviewing your business strategy to ensure that confidential information that you have categorized as a trade secret is still relevant to your business goals and to that connection still licensing. Ensure that these are covered very well in the agreement, and that there is audit rights, and so the licensor has the permission, which is practice. It's not only stated in the contract, but actually practice to ensure that, okay, I'm checking to see how the measures that you have in place to protect this information that is relevant to the branding of the business and to even the actual commercial relevance of the business, of the food and beverage business in Canada and globally as well. I'll end it there for now. Thank you.
Thank you so much, Marcia. And I'm very conscious of the time. So we've got 9 minutes left. I know that following this, this block of time, there's a 15-minute break. So I'm going to forgo the question at the end, but Ron, just so you don't feel like, you need to like absolutely marathon through your time. I'm happy to stay a few minutes after 4 p.m. and obviously for those who have to leave right at 4, feel free. But Ron, thank you so much for being here. I've never had the pleasure of meeting you, but I've been reading your articles on food and on food law in Canada for many years. So Ronald Doring was previously the president of Canada Food Inspection Agency and is now counsel at Gowlings. He will be providing us an update on the temporary exemptions to interprovincial trade. So I'll let you take the stage. Thanks.
Thank you, Jessica. Last June, in response to the COVID crisis, the CFIA announced that it would allow temporarily by ministerial exemption meat from federal plants to move in interprovincially upon the application of the province. If the province proves it has a shortage of meat. No province, as far as I've been able to determine, ever made that request, and therefore, in a sense, it was a dud. But what this did is it led to a widespread discussion. If we can do this for emergencies, why can't we just permanently get rid of this unnecessary trade barrier? Why can't we just have one system of meat inspection in Canada? So I wrote my Food in Canada food law article, a column that's been running for 19 years now. It scares me to think that, to answer that question. And the title was Meat Inspection, Some Interprovincial Trade Barriers Are Fully Justifiable. The column got quite a pickup actually in social media and in the Western Canadian print media. So that is why I assume my old friend Glenford, who invited me to be the first speaker at the very first conference. We had no idea what we were starting there, Glenford, and the range of topics we've got today. But I'm assuming that's why Glenford asked me to speak today about this. And so my topic is, why can't we have one national system of meat inspection? As many of you know, or should know, under our Constitution, trade and commerce activities within the province are primarily a provincial responsibility. With very few exceptions, the federal government only has jurisdiction to legislate in relation to products that cross provincial and international boundaries. So the trade and commerce statutes, like the old Meat Inspection Act, now encompassed in the Safe Food for Canadians Act, can only apply to interprovincial or international commerce. So if Canada wanted to have one system of meat inspection, even wanted to, it couldn't. Federally regulated meat plants must strictly adhere to thousands of rules and hundreds of pages of regulations. Every plant is overseen by a full-time on-site CFI veterinarian and several inspectors. Well, these large plants account for 95% of the volume of meat produced in Canada. They represent only 5% of the actual meat plants. All the others fall under exclusive provincial jurisdiction. And that's where we have this really messy regulatory patchwork. Some provinces have virtually no mandatory meat inspection. Animals can be slaughtered, processed, and meat sold at retail with no regulatory oversight at all. Some provinces have really impressive laws, but no enforcement. When confronted with these regulatory gaps in the past, many provinces replied that there was no real scientific evidence that meat from provincial plants is any less safe, and they argued that it was completely unnecessary to apply the level of federal regulation to a plant that might produce process fewer animals in a year than the federal plants slaughter and process in an hour. But if you're the province that does have a modest inspection system, you're completely justified, seems to me, in supporting federal regulation that makes it an offense for the uninspected provincial meat to come into your province. The province might be right next door, and I could give you examples of that. Moreover, national enforcement rules in trade law would disallow Canada to deny entry to meat from other countries if we allowed meat from non-federally registered plants to cross provincial boundaries. This is the national treatment rule. I was going to spend some time on that, but I know we're running out of time. So when a columnist argues for the removal of the prohibition against interprovincial movement of meat products, stating that it is quote, incredibly silly, quite ridiculous really, to suggest that beef products processed and inspected in Alberta or Ontario wouldn't meet the safety requirements for consumers in Manitoba or Nova Scotia. What this person is doing is demonstrating a profound lack of knowledge of both the law and the facts on the ground. But one of the things that I've seen in my 25 years of close dealing with the food industry is that he's with good company. Most Canadians have little understanding where their food comes from or how it's processed. This underlines much of what we're doing here. So this is an internal trade barrier that's not going away. Provincial governments do not want to close small plants or to incur the huge investment that would be required to enforce mandatory inspection. And of course, the federal government has no interest whatsoever in assuming the regulatory and legal responsibilities for hundreds of small provincial plants. The dual system is here to stay. Learn to live with it. This is one internal trade barrier that's entirely justifiable. So the whole matter, in my opinion, was an uninformed tempest in a teapot. We need, and that was the original reason for this association and these policies, to engender a discussion on a whole range of interesting topics relative to the food safety system. But I'm happy to report this isn't one of them. So I'd just like to conclude again by saying that I've come full circle here. I was the opening speaker at the very first conference, and I'm very grateful to be back. And I want to take this opportunity to recognize and thank Glenford for the leadership he's shown throughout all this time. So thanks for the invitation. And I finished in less than 7 minutes.
Very, very impressive, honestly. Thank you so much. And I share your thanks to Glenford. It feels like a kind of full circle moment to have you here closing this panel and having opened the first panel in Halifax. So thanks for highlighting that. That's really nice. And before I let everyone go, I just also wanted to highlight that there will be a blog post on foodlaw.ca about this panel. It's being written by two of our very helpful and very active student volunteers, Elizabeth Yu and Julia Whitmer. So thanks to both of them. And the question I was going to ask at the end was, what changes each of you see in your field that you from COVID-19 that you anticipate are here to stay or that we can expect to see emerging? And I'm wondering if maybe each of you could take a moment to send me, and I will forward to our student volunteers, 1 or 2 sentences in response to that question that we can then include in the blog post, so that everyone attending here could still get the benefit of your insight and expertise on what we can expect to see coming in the next few years. And on that note, thanks to all of our speakers, thanks to all of our conference attendees, and looking forward to seeing everyone at the future panels over the next 2 days. Thank you so much.
Thank you.